So you opened your mailbox or your email, and there it is, your EEOC Right-to-Sue Letter. Now you're looking at it, wondering, what do I do next? First, don't panic. It's not anything to panic about. The letter doesn't mean that you won, and it also doesn't mean that you lost. What it does mean is that the clock has started, and what you do next matters. Hey, I'm Tiffany, and this is Pro Se with Tiffany, where I break down the legal process in English, and I represented myself in federal court. My goal is to help you and others navigate through the court system by yourself, okay? So we'll walk through what happens after you receive the Right-to-Sue letter. But first, we need to back it up a little bit. Before we start talking about filing in federal court, we want to know, it depends on your case. Before that process of where the EEOC issues a right-to-sue letter, maybe they decided, like we talked about in the last few episodes, maybe they decided that they would do mediation. So what does that mean? So mediation is a chance to resolve your case before the investigation continues, okay? Participation in mediation is voluntary, okay? It has to be voluntary on both sides in order for it to work, hence mediation, okay? There will be like a neutral mediator. So the mediator is not there to be your lawyer. The mediator is not there to choose sides or anything. The mediator is there for facts. Remember, facts over feelings, okay? Okay, so if you do have the opportunity to go on mediation, both sides do agree, just make sure you go there with all of your evidence. Remember, proper preparation prevents poor performance, and that's where we're aiming to do. That's if that's even offered, right? This process is completely confidential. Nobody can talk about it. Nobody knows about it. And what's said there stays there. You cannot talk about that after the fact or anything to no one, okay? That's the purpose of it being a mediation and being confidential, okay? If there's an agreement reached, obviously paperwork, okay? And then the EEOC will decide it stops there. We don't have to continue with the process. Now, if there is no agreement reached, right? So if neither side comes to an agreement, then the EEOC will continue to investigate. And another thing I want to add, and I added a little bit before, not every investigation with the EEOC, you end up getting a right-to-sue letter. That doesn't happen, right? So just keep that in mind. They might decide like, okay, we're not going to move forward with this or whatnot, and depending on your case, because every case is different. I'm not a lawyer. I'm just the person that took someone to federal court on my own, pro se, and I'm here to give you all that knowledge and those skills to kind of help you through the process. Because granted, a lot of mediations, okay, we're going to stick on that for a second. A lot of mediations, they're to help both sides, because going to court is costly. It costs thousands and thousands of dollars to actually go to court and to proceed through the process, because there are different stages through the process of court. It's costly. Okay, so, that's the part about getting EEOC involved and making sure you're under the right authority. Obviously, the EEOC, if we're talking about those protected things that we talked about in the last couple videos, right? Discrimination, age, sex, gender, religion, ADA, disability, anything like that. Those are things that will go through the EEOC generally. Decides to not take on your case, that does not mean that you still don't have the right to sue. That just means they're saying like, we haven't, we haven't found sufficient evidence or whatever, and we decided not to move forward, and we decided not to mediate, and that is fine. So what is a right-to-sue letter? A right-to-sue letter is the green light, right, for you to take your case to the federal court, okay? What it is not, and basically it's that the EEOC found that there was sufficient enough in a way, evidence for them during their investigation to grant you this letter. Okay, so you need that. It's like a permission slip to move on to the next step of this thing. What is not? It's not a guarantee that you're going to win your case. It is just a letter saying you have the right to sue in federal court. It is not a decision or anything like that. It's not the end of your options though either, okay? It's the beginning of your next step, right? So without a right to sue letter, most employment discrimination claims cannot move forward in the federal courts, okay? But because this gives you the legal authority to move forward and hold the responsible party accountable, is what I'm trying to say, okay? So that's what your right to sue letter is. Now, you got this right to sue letter, okay? You have 90 calendar days to file your case in the courts, okay? Can't be a day late or anything like that because they'll file motion to dismiss, okay? The clock starts when you receive that letter. If it's email and it's dated, it starts when it was emailed. If it's in like your Dropbox or something like that, mail wise, genuinely, you'll get a few days or whatever, like, cause no one knows when you're going to get the physical mail in your hand. So a lot of stuff is digitized nowadays. So got 90 days to do that. Do not remember preparation prevents poor performance. We're not waiting to the last minute to do all that. Okay, so we are going to go ahead and start that process. And that's you starting which you should have already been, because we've talked about this. You should have already been researching, finding out information, different things, because you are doing this pro se. That means by yourself. Okay, if you're just now joining us in this series, we're on episode 4 and we're talking about the EEOC letter, okay? So, you should have already investigated that, but just remember, a day, you cannot be late. This is a time thing, okay? Clock starts, don't delay. Now, before you file, right? So, one, you need to find out what court you need to file in. It depends on the state that you're in. What court do you need to file? And genuinely, you will file in the state that the incident occurred. Okay, so whatever state you're in, if for Illinois, I'm in Illinois right now. So, if, we're working for an employer in Illinois, we will file in the state of Illinois. We're working for an employer in Alabama and we move to Las Vegas, it has to be the state where the employer is located to file that charge, okay? Because that's their home state. Regardless of where you live, it can be, a lot of things are, like I said, digitized now. So just remember, while you're doing that, you want to gather in your evidence. You want to build your timeline. You want to have your witnesses. And you genuinely need to know what laws apply. So when you do get ready to fill out everything, you have everything in order, because proper preparation prevents poor performance, and we document, okay? Okay, so know the relief that you're requesting, right? And the relief is the remedies, right? You request in your lawsuit, they should also match the harm that was done. So if you lost pay and you're requesting back pay, that's back pay, those wages that you lost. Front pay, wages that could have been earned, okay? And then you have compensatory damages. That is mental anguish, emotional distress, pain and suffering, and other non-economic harm. Punitive damages, when they are permitted, you want to punish the employer for malicious, reckless, or oppressive conduct, okay? It's not available in all cases, but if you could prove that, then that's what you will put down. Injunction relief, it's court orders requiring the employer to stop unlawful behavior or change policies, okay? And then you have attorney fees. So if you have an attorney, but we don't need to talk about that because you don't. Remember, pro se, you are there by yourself, so you should not have any attorney fees, okay? You got your remedies, right? So then you need to know what are you suing them for? What laws that apply to this? Is it Title VII under the Civil Rights Act? Is it ADA, the Americans with Disabilities Act? Is it ADEA, the Age Discrimination Employment Act? Is it FMLA, the Family and Medical Leave Act? Is it the Equal Pay Act? Is it Section 1981? When applicable, that means protect the rights and to make and enforce contracts without race discrimination, including the rights of employment. State law claims. Some of those claims, many states have their own anti-discrimination laws that may offer additional protections and remedies. Okay, so you need to, when you're doing your paperwork, when you're filling everything out, you need to know what laws apply so that you can explain how you have documentation of what law was for that your particular claim. Okay, what law was violated for that claim, shall I say? Okay, because if you're under the age of 40, you're not going to, and even if you're not suing for that, right, but you're not going to go ahead and put in the Age Discrimination Act was violated because it doesn't apply. So if it doesn't apply, then it is what it is. So again, we're going to go back to when you're filing your lawsuit. So once you got all the information, you have the paperwork filled out that you need, okay? Remember, we're going to make sure that we are going to the right court, okay? Okay, where you worked, where the discrimination happened, where is the employer located? That is where you will file your lawsuit. When you file, bring your right-to-sue letter. If that applies to what you're filing for, okay? And like I said, in most cases for employment discrimination, you need a right-to-sue letter. Some you don't, but it all just depends on you and your case. I'm not a lawyer. I'm just somebody that went to court, to the federal government, on my own pro se. That is all. I am just like you. I'm a person, and I don't think anybody has thousands of dollars sitting around to, just throw away to a lawyer when this stuff can be done by yourself. You don't need to do that. And this applies to all laws. This applies to all courts. Obviously some are harder than others, but if you take the time to be diligent and study and research and know your rights, you can do it. I'm telling you, I did it. You can do it, okay? So you'll have all your evidence, your emails, your photographs, everything. Remember, proper preparation prevents poor performance. We want to make sure that we are prepared adequately when we're doing this. We have to be super organized. I was really, really organized and on top of everything because this is something that matters. Because remember, not only are we doing this for ourselves, we're doing this for other people that are going to come behind us. It depends on what the situation is. We want to try to help them. People don't like to get sued, but sometimes people need to get sued. Okay, sometimes people deserve it because they are just not right. They're not good, right? But, again, everything is a process. And remember, take the feelings out. Feelings don't matter. Yes, you were wrong. Okay, boo-hoo. Prove it. Prove it. That's where we're at. Proving it, okay? So you need to make sure you document. But I've learned along this process is this. If something happened to you and you were wronged in any way, shape, form, or fashion, you have the right to have a voice and to speak up. You do not need to sit there and continue to take abuse or a misjustice or whatever. You don't have to sit there and do that. And you should love yourself enough to say, I'm not doing this. I'm not taking this. I've seen it too often where people wait. These people don't give a fuck. And I'm being real. And I'm not saying that to discourage anybody from working or doing anything like that. These companies, been working since I was 14 years old. These companies are all the same. They are no different. They have a set policy and a set of rules, and they do what they want to do if they can get away with it. So if you're working for someone, they're mistreating you, they're misusing you, they're doing something illegal, you have a duty to say something. I get it. Times are hard out here. But I promise you, if you have documentation of the negligence, of what's been happening to you, report it, take the steps that are listed in their policy, do what you got to do, and if they don't act on it, then that's on them, and then you take them to court. Simple. I'm not telling you to sue everybody. What I am doing is, if the shoe fits, wear it. Okay? So we'll continue. We'll do we'll go to episode 5, and we'll continue along the process of, after you got your EEOC letter, your right to sue letter, what's next, and because that is such a big thing. So maybe I'll do the next episode on how to actually file in court and what papers you need to request, especially if you don't have any money, request some type of financial help to file these cases. Okay, so thank you. Welcome to Pro Say with Tiff. I appreciate you all so much. Go ahead and like, subscribe, follow. I also update these episodes on my YouTube channel. It's Pro Say with Tiff. I update these on my YouTube as well. So I'm just here to give you all encouraging word of advice, and also just to teach y'all something. This is only educational purposes. I'm not a lawyer, and I can't give you legal advice. But what I can do is show you the way to take care of yourself and to advocate for yourself. All right.